The average process, the steps, and the timing of an OFAC removal case or delisting case vary greatly. The more common way to seek rescission of an OFAC designation is through OFAC's administrative delisting procedure. And the OFAC delisting procedure affords parties two ways to argue for removal of the sanctions. The first is to request a reconsideration of the initial designation based on an insufficient basis for that designation. In other words, and simply put, you can ask OFAC to go back and revisit their decision because you believe that they made a factual or legal mistake in imposing the designation. And in doing so, you can present evidence to them, as well as your arguments as to why there was an insufficient basis of the designation. Let me just say this, OFAC hates to hear that argument, and most parties who pursue that line of delisting requests are denied, based on my experience, and they're denied after years and years of consideration. The other way that you can follow OFAC's procedures for a delisting matter is to assert a change in circumstances to the circumstances which gave rise to the designation. In other words, you're not saying that OFAC got it wrong. What you're saying is the circumstances that they cited as the factual basis for imposing the sanctions have changed, and as such, the designation is no longer applicable. There's another way to present that same argument, in addition just to presenting information and evidence and argumentation that the circumstances have changed, which is to propose remedial measures which, if adopted, would negate the basis of the designation. In other words, you go to OFAC with a proposal and you say, listen, I don't know what you guys think about me. It's besides the point. You have concerns. I'm here to address those concerns. And I'm here to address those concerns by my willingness to engage in the following activities, such as providing information on financials, divesting certain relationships or from certain assets, engaging in ongoing certifications that you're not involved with certain sanctioned actors, etc. And in exchange for these measures, OFAC will agree to remove the party from the list. They do this by entering into what's called the Terms of Removal Agreement, which is a written contract between the agency, OFAC, and the subject person, the designee, which states, okay, I'm going to execute on these measures, you're going to remove me, this agreement will be in place for a certain period of time. If you want to argue that there's a change in circumstances, you'll fare better in making that argument, typically. You're still going to likely be waiting about 2.5 to 3 years.